aspects of the legal framework to be addressed by my colleagues in due course over the next 4 days. Let's start with the context, the negotiation of the convention. Mr. President, Raphael Lemkin invented the word genocide. He constructed that word out of the Latin and Greek words genus and cide, to mean the killing of a group or of a people. And here you can see the word in his own writing on the screen, a document that may be found in the rare book and manuscript library at Columbia University in New York City. He chose the word genocide as the title for Chapter 9 of his book, Axis Rule, which was published in November 1944. I've taken the liberty of bringing a copy of the first edition of that book, my own copy, to court today. As you'll see, it is personally inscribed by Raphael Lemkin in the Nuremberg courtroom on the 4th of July 1946. This room today is in direct connection with courtroom 600 and the Palace of Justice. And I invite you, please, to read all of Chapter 9 of that book. It's not long. It's available online. As you read Lemkin's words, I suspect, like me, you may be struck by two things. First, the convergence of Lemkin's account of the indicators of genocide that he found in the 1930s and the 1940s with the evidence that is before you in this case. And second, that the approach taken by Raphael Lemkin is fully consistent with the approach taken by this court in its jurisprudence. As you will know, despite the crime being argued before them, the judges at Nuremberg failed to mention the word genocide at all in the 1946 judgment. And this is what prompted Raphael Lemkin to engage in efforts elsewhere, leading up to the first ever session of the United Nations General Assembly, and ultimately his efforts bore fruit in December 1948. You, the judges of this court, need no reminder of the horrors which preceded and precipitated the formulation and adoption of the Genocide Convention, and which led states parties, including so many of the countries which you are each from, to heed Lemkin's exhortation to bring an end to the odious scourge of genocide. It was an imperative task in 1948, as the crime of genocide took its place alongside war crimes and crimes against humanity. And to be clear, while international law treats these crimes as distinct, it does not establish a hierarchy among them. Sadly, the task of 1948 remains as imperative today as it did then. And there's one aspect of the negotiating process to which I wish to draw the court's attention. Myanmar suggests that its crimes against the Rohingya, and they are crimes, cannot be characterized as genocide. Why? Because simply too few Rohingya were subjected to abusive acts. The argument is fallacious, as we will show in the coming days. But in this respect, the negotiation process of the convention is important, as with Raphael Lemkin's intentions, because it makes clear that the crime of genocide is not a numbers game. The negotiating process involved 3 drafts, and in reaching agreement on the 3rd and final draft, there the negotiators addressed the scale of destruction necessary to constitute the crime of genocide. The negotiating committee recognized that the convention should include as instances of genocide such crimes as group massacres or individual executions on the grounds of race, nationality, or religion. France's delegate promoted this position, allowing that even a single death could constitute genocide. That is the approach enshrined in the Convention's wording, that there must be an intent to destroy the group in whole or in part. Of course, in this case, terribly, there is not just a single death. There are thousands of deaths, and tens and hundreds of thousands of other genocidal acts, with upwards of 1 million human beings today in Cox's Bazar. Pause for a moment and reflect on that number. Over 1 million people. But let us not forget that the words "in part" were explained by Mr. Rafat, who served on Egypt's delegation, as being intended to achieve the aim of the French amendment. I turn to subsequent practice. This court's first interpretation of the Genocide Convention came not long after its adoption, the famous 1951 advisory opinion. And there the court recognized and underscored the Convention's purpose, a purely humanitarian and civilizing purpose. The high ideals which inspired the Convention, the court said, provide by virtue of the common will of the parties the foundation and measure of all its provisions. And so it is today. That purpose and those ideals inform the way in which the court interprets and applies the provisions of the conventions in this case. The court's jurisprudence on the convention, in particular with the Bosnia and Croatia judgments of 2007 and 2015 respectively, is the lodestar on which the Gambia's application has been based. Other aids to interpretation, including the jurisprudence of the international criminal tribunals and national courts, and it is worth mentioning that in particular it is the courts of Germany that have in recent years played the leading role in relation to rulings, judgments of genocide perpetrated in northern Iraq and Syria, including against the Yazidi population, as well as the findings of international commissions which provide guidance on issues arising under the convention, as the interveners have made clear. But it is the court's own jurisprudence, your jurisprudence, that has played a central role in guiding the Gambia's approach. And we've fully relied on that jurisprudence in the decision of the Gambia to bring the case and in arguing the case in our written pleadings and in the course of these oral hearings. That approach of the court informs the views of all the interveners and the Gambia in these proceedings. And both parties and all the interveners agree on the basic and foundational principle articulated with force by the court in the Bosnia judgment, that a state is prohibited from committing genocide and a state may be held internationally responsible for the crime of genocide. And we note and agree with the Democratic Republic of Congo's very helpful summary of certain additional significant points of agreement. The DRC's submissions include the following. First, that a situation of armed conflict does not preclude the crime of genocide. Second, the Convention does not require that a genocidal intent be the sole motive pursued by a respondent state or its agents, but it permits of multiple and overlapping motives. Third, a genocidal intent does not have to be expressly stated and may be established or inferred either from particular circumstances or a pattern of behavior or conduct. And fourth, the requirement that a substantial part of the protected group is targeted does not refer to a purely quantitative criterion, but is to be interpreted in the light of quantitative, qualitative, and geographic factors. These are very important points of consensus on the basis of which we say the court can proceed. I turn now to the definition of genocide the famous Article 2 of the 1948 Convention. This provides as follows. In the present convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial or religious group as such. The 5 acts that follow in the text of Article 2 are A. Killing. B. Causing serious bodily or mental harm. C. Deliberately inflicting conditions of life calculated to bring about the group's physical destruction in whole or in part. D. Imposing measures intended to prevent births. And E. Forcibly transferring children to another group. Any one of these acts committed with the requisite intent is sufficient to constitute the act and the crime of genocide. And my colleagues will take you to evidence over the course of this week which will show many acts falling within the first 4 categories of Article 2 having been committed by Myanmar against the Rohingya group. In the counter-memorial, Myanmar argues that the number of victims is relevant to the determination of whether the actus reus of genocide has been committed. This is wrong. It makes this argument specifically in relation to the actus reus of killing under Article 2A, and Myanmar invites the court to conclude that unless killings are, and I quote, part of a campaign committed on a scale that is capable of bringing about the physical destruction of the relevant group or part of the group, they will be inadequate to constitute the actus reus of the crime of deliberate destruction of a human group. You can read that at paragraph 4.61 of the counter-memorial. Pure invention. There is no basis in the text of the Convention or the jurisprudence of the Court, or as I've already explained, in the negotiating history of the Convention to support this erroneous claim in respect of the actus reus under Article 2A. To the extent that numbers may ever be relevant, it's a factor that goes not to actus reus, but potentially to the question of whether the mens rea of genocide has been made out. This is because it may, but not necessarily, it may bear on whether there is a reasonable inference that acts were carried out with the specific intent to destroy the group. That aspect of establishing the existence of the mens rea of genocide is a point to which I will return on Wednesday, to be followed by Mr. Reichler. But to be clear, there is no numeric or substantiality threshold inherent in the actus reus. As this court has observed, and the chapeau of Article 2 makes plain, there are, and I quote, 2 constituent elements, end of quote, to genocide, the mens rea and the actus reus. And whilst both must coexist for genocide to have been committed, they are, and I quote your words, analytically distinct. End of quote. The issue of numbers or the existence of concerted plans plays no part in establishing actus reus. And I also wish to underscore that killings under Article 2A are only one of 5 possible genocidal acts, 4 of which have plainly been established in the evidence that is before you. The Gambia does not contend that acts within the scope of Article 2E, that's to say forcibly transferring children out of the group, took place. But acts in all 4 other categories of Article 2 have been committed. And as the 6 joint interveners have underscored, and I quote, there is no hierarchy among the underlying acts of genocide, and the legal relevance of all acts targeting a protected group must be emphasized, end of quote. Thus, although terrible killings undoubtedly have occurred in this appalling case, it has to be underscored that the other modalities of the actus reus are just as central to the Gambia's case as acts of killing. Prominent in this case are acts falling within the scope of Article 2, paragraph B, causing serious bodily or mental harm to members of the group. The kinds of acts falling with this category are sadly diverse in this case. They include acts of sexual and gender-based violence, acts causing physical and psychological harm, and acts of forced displacement. And you're going to hear a lot more from this from the witnesses next week. I make two particular points in this regard. First, Myanmar's campaign against the Rohingya is appallingly characterized by widespread sexual and gender-based violence. As the joint interveners have submitted, and as the Gambia has also affirmed, the harm caused by such acts is by its very nature and effects almost universally serious. This has been recognized by this court in the Bosnia judgment, which endorsed the vital findings of the Rwanda tribunal in the Akayesu case. And that case made clear that the effect of rape and sexual violence are one of the worst ways of inflicting harm on the victim as he or she suffers both bodily and mental harm. End of quote. These are genocidal acts. They fall within the scope of Article 2, paragraph B. All the more so where, as in the present case, children are involved, a point that is made with force by the interveners. They may also constitute actus reus under Article 2C and 2D. Very frankly, the evidence you're going to hear about this week is dreadful, and it's going to be very tough to listen to some of it. But listen to it we all must, and draw the necessary conclusions from it. We say you must. Second, forced displacement. The permanent expulsion of a people from their homeland is plainly capable of causing serious mental harm to members of the group, alongside any physical harm suffered in the course of their expulsion or which contributed to their fleeing their homes. In this case, it affects not only hundreds of thousands and upwards of 1 million human beings, but expulsion is recognized by the ICTY as capable of being a genocidal act. And let's be clear, expulsions do not have to result from the formal removal of people by bureaucratic state processes or the use of Auschwitz-style cattle cars. Expulsion arises in this case after the ransacking of villages, the burning of houses, the constant threat of violence against all who remain. It is these acts that contribute to the forced displacement that forms the actus reus within Article 2, paragraph B. And as the International Residual Mechanism for Criminal Tribunals has made clear, forced displacements do not always require physical force. They can, and I quote, be met through the threat of force or coercion, such as that caused by fear of violence, duress, detention, psychological oppression, or abuse of power, or taking advantage of a coercive environment. It is the absence of genuine choice that makes the displacement unlawful. End of quote. And this is exactly what has happened in the present case, along with the use of physical force, causing grave harms to the Rohingya within the meaning of Article 2, paragraph B. Such displacements may also be genocidal actus reus within the terms of Article 2C, as the court recognized in the Bosnia case. This point has also been widely recognized by international criminal tribunals in genocide cases. For example, in the Ptolemyer case, the Yugoslav tribunal held that underlying acts of genocide may include, and I quote, methods of destruction that do not immediately kill members of the group, but ultimately seek their physical destruction by systematically expelling members of the group from their homes. Second constituent element of genocide, namely the mens rea. This is a subject that has received a lot of attention, and not just from lawyers. Writers, journalists, psychiatrists, psychoanalysts, psychologists have all turned their mind to the key point, the question of intent. Now, I note, before turning to the dolus specialis of genocide, that each of the underlying actus reus acts have their own mens rea, which must be present in the perpetrator when the act is done. And I quote, "Killing must be intentional, as must causing serious bodily or mental harm. Mental elements are made explicit in paragraphs C and D of Article 2 by the words deliberately and intended, quite apart from the implication of the words inflicting and imposing. The acts, in the words of the International Law Commission, are by their very nature conscious, intentional, or volitional acts." End of quote. And so, for the actus reus to be present, the relevant acts must have been committed with the requisite volitional mindset. In most cases, it's going to be straightforward to establish that an act is intentional, as we say it is in this case. But, alongside this aspect, and as an essential ingredient in genocide, is the existence of what has been called a dolus specialis. The intent must be to destroy in whole or in part a national, ethnical, racial or religious group, and to do so as such. Now let's turn first to the first part of this totemic chapeau, the fundamental basis of genocide, the core feature of the crime. What distinguishes it from other crimes is that it is predicated on establishing an intention to destroy. The intention, however it is expressed, must be to achieve the physical or biological destruction of the group in whole or in part. Although the extent to which such destruction is in fact achieved is not relevant to the establishment of the dolus specialis. The victim of a genocide must be part of a recognizable and definable group, joined by a common nationality or ethnicity or race or religion. The intent must be to destroy the group as such. That requirement was explained by this court in the Bosnia judgment, as some of you will know very well, as underscoring that genocide requires an intent to destroy people who share a particular group identity because of who those people are, as the court said. The words "as such" emphasize that intent to destroy the protected group. In this regard, they are targeted not because of what they have actually done or might do, but simply because of who they are. That is what counts in genocide. And let's be clear, there's not a shred of doubt, none, that the Rohingya are a group within the meaning of the convention, and there is not a shred of doubt that they have been and that they continue to be to this day targeted as such. My colleague, Mr. Suleiman, is going to address the point later today. Alongside these requirements, the chapeau to Article 2 stipulates that the intent has to be to destroy the group in whole or in part. As the court's findings in respect of Srebrenica make plain, a targeted part of a group has to be a substantial part. But that does not mean that it has to be a numerically significant part in the context of the group overall, where other factors combine to make it substantial. As the court stated at paragraph 296 of the Bosnia judgment, substantiality is to be assessed by reference to three elements, namely quantitative factors, relevant geographic factors, and emblematic or qualitative factors. The evidence you're going to hear over the course of this week and next will leave no doubt that the targeted part of the Rohingya group was by reference to these three elements, and it was substantial. I turn next to the need to establish the presence of the dolus specialis. As the court has made clear, this can be either on the basis of direct or indirect and circumstantial evidence. In the Croatia judgment 10 years ago, the court clarified its approach to identifying the existence of dolus specialis. It said, and I quote, "In the absence of a state plan expressing the intent to commit genocide, it is necessary in the court's view to clarify the process whereby such an intent may be inferred from the individual conduct of perpetrators of the acts contemplated in Article 2. In its 2007 judgment, the court held that, and you'll see the words here on the screen, the dolus specialis, the specific intent to destroy the group in whole or in part, has to be convincingly shown by reference to particular circumstances, unless a general plan to that end can be convincingly demonstrated to exist. And for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent." End of quote. Now, those are words, no doubt,